Please.
All right. Court of Appeals Division 1 is now in session.
Good morning. Please be seated. This is the time set for oral argument in our cause number 1 CATX 2000-0004, South Point versus the Arizona Department of Revenue et al. Counsel, we've read the briefs. We've discussed this case in conference this morning. Please keep that in mind as you address the court today. I would also mention that it is being recorded so that when you argue your position, if you could state your name before the argument and identify who you represent. We are social distancing, so if you could remain seated and speak into the microphone so we can record it. Counsel for appellant, you're reminded that you want to reserve any time. You may do so. You just need to keep track of that yourself.
Sorry.
Mr. Cooper, did you draw the short straw today?
At least I've gotten to work both sides of the room.
There you go. All right. All right. You may proceed.
May it please the court.
My name is Ben.
I'm sorry. May it please the court. My name is Ben Cooper, and I represent South Point Energy Center. Mojave County's attempt to tax the permanent improvements to the leased Fort Mojave reservation land is based on a myth. The myth is that this is a tax on non-Indians. Department of Revenue in the county goes so far as to assert that the legal incidence of the tax, which is all that matters under this court's decision in Carball case, is on non-Indian owners. That is not true. It's not true under longstanding Arizona law. And it doesn't work as an attempt to drive a wedge between the permanent improvements and the land, a separation that no federal court has ever recognized when it comes to preemption. But it's not true as a matter of law because in Arizona and elsewhere, property taxes such as the ones at issue are on the property themselves. They are not a tax on the owner or the privilege of ownership. Those are excise taxes. This is not an excise tax. Arizona has recognized the nature of the property taxes at issue, going back to the Pothast case in 1934, Santos and Simon in 1943, and Peabody Coal in 1977. This is a tax on property, not on owners. This is not a possessory interest tax like California uses. Arizona abolished its possessory interest tax over 20 years ago. It's not a GPLET, a government property lease excise tax. It's not a sales tax. This is not the kind of tax that courts have ever upheld when applied to the land or the property, regardless of who owns it. Because this is a tax on property, not a tax on owners, the owner of the property, or the ownership, the privilege of ownership, the ownership is irrelevant, particularly the racial identity of the ownership. That is why the Ninth Circuit Chehalis Reservation said that ownership was irrelevant. It doesn't matter because this is an ad valorem property tax on the property, not on the owner. That is why the BIA regulations say uniquely as to property taxes on permanent improvements on leased tribal land, that ownership is irrelevant. And they're not dealing with the BIA regulations with a specific factual setting of who owns it, whether there's any interest of Indians in the owning entity. They say it's irrelevant, and they say that only about property taxes on permanent improvements. To repeat, ownership is irrelevant because this is not a tax on ownership. That is why all the federal authorities rely, in terms of preemption, on the relationship of permanent improvements to the land, not on the identity of the owner. If the identity of the owner had been the test, then the courts would have all said, would not have talked about the nature of permanent improvements running with the land. They would have said you can't tax Indians on the reservation and this is a tax on Indians. But that's not what all the courts said. The defendants are asking this court to become the first court in the country to rely on the identity of owners in upholding a tax on a property tax on permanent improvements to least troubled land.
Mr. Cooper, is there a stipulation in the record that the improvements at issue are in fact permanent?
No, and the reason is because of the circuitous way this came up.
Right, and I should have just asked this
Right.
question. Are we really in a position on this record to conclude that the improvements at issue are permanent?
I'll put it this way. To begin, if the court holds that the property is preempted under Bracker, that would apply to permanent improvements and to personal property. So the court wouldn't have to get into the permanent improvement, non-permanent improvement distinction. And I think the court acknowledges that you understand why we did not do the full briefing on permanent improvement. The answering brief is silent whether the defendants think that under federal law, the facility is a permanent improvement or not. Their position has always been that it's not a permanent improvement because they choose not to tax it as a permanent improvement. But that's not the test. The test is one of federal law, not state law. And so we don't know what their position would be under the White Coat test, which is the prevailing test for what's a permanent improvement under federal law. In a sense, and if you look at our record 72, Exhibit D.
Counsel, I thought you recognized that some of it would be personal.
If it's a matter of some minor office furniture or laptop computers, yes, that's the kind of thing I think if the court decides that whatever is a permanent improvement under federal law is preempted, and personal, if that's the result, personal property isn't. I would imagine, and it's clear from the court's analysis that federal law governs it. I think we could work that out on remand if a limited remand was necessary under that legal construct. But I think the perfect example of how this test works is what happened in Washington State after Chehalis Reservation was decided. Because when the state gave out its guidance, and it's in R72 Exhibit D, and it was explaining that the test is federal law for what's a permanent improvement, and it said, the example they gave was, mobile homes that are permanently attached to utilities have lost their identity as a mobile unit. Therefore, they would be considered permanent improvements. So basically, if you wire it in, if you take it off the wheels and put it on, I don't think if the standard is clear that it's federal law, there's really much for us to argue about. And that's why what we had originally convinced the trial court, after you do the Chehalis Reservation categorical preemption, turn next to the issue of what's a permanent improvement, because we think what's going to not be permanent, the personal property is going to be pretty minor, and we might not even pursue it. I mean, that was the logic of it.
Explain procedurally why it didn't play out that way. I mean, we just kind of get to that minute entry where the court orders a record about Bracker, but doesn't give guidance, and it looked like there was kind of an unanswered scheduling request saying we had this set out, but we're kind of in conflict about where we go. Why was it procedurally, from your perspective, that you weren't able to, as you say, fully brief that issue?
There had been a disagreement. I would think both sides were in agreement. We'll do Bracker first. We'll do categorical preemption first. And then when the court said,
you mean Chehalis first?
Yeah, we'll do Chehalis, the issue of categorical preemption. And I think the analysis then was, once the court seemingly ruled that would not apply, it said, okay, why don't you go to Bracker next? Because if there's nothing preempted at all, we don't have to engage in a discussion of what's a permanent improvement and what's not. And so the court changed what we understand, the order of briefing, and then ultimately decided there's no point, but then, in a sense, tried to backfill its analysis by saying that, it's not a permanent improvement anyway because it can be removed. Well, that's not correct. As I tried to tell the court in our argument, that's not correct, because permanent improvements can be removed, as we know from the underground garage near this courthouse when they, in downtown, when they tore it out of the ground and removed it, it wasn't any less a permanent improvement. That's not the test. It's not the test under federal regulations. It's not anyone's test. But that's where we are now. There was no record for it. But we think that if it's clear that federal law governs it, under federal law, a 500 megawatt power plant is most certainly a permanent improvement, even if there's some incidental personal property around there. That's not where the value is. The value is in the power plant itself. And that would cost tens of millions of dollars and years to decommission and haul off.
The way I understand it, but I'm playing this out, is you've conceded that there's some personal property.
Yeah,
So
yeah, there are, you know,
We can't, even if we bought all of your arguments to the end, all we could do is vacate and remand for a determination of what's personal and what's permanent.
that's correct, Your Honor, but as long as the legal questions are decided, you know, what's the applicable test, things like that, then the application of that to the facts on the ground, you know, taxpayers and taxing authorities work those out regularly once the courts rule on what the rule is. If I don't anticipate that would be any kind of, if that's the nature of the remand, I think it's going to break out very easily. The problem has been the rulings as to whether there's categorical preemption and what is the test for what's a permanent improvement. But again, the state hasn't disagreed on appeal with the applicability of the White Coat test. Now, going back to my original comment, if Bracker preemption also applies in addition to categorical preemption, then it really doesn't matter whether property is personal property or permanent improvements, because the taxes would be preempted either way. So it only becomes a relevant question if the court has a sense of split decision. The problem with the tax court's ruling on categorical preemption, and the reason I emphasize that is because that's a straight line rule, not any kind of balancing rule, is that it creates untenable and unnecessary split with the Ninth Circuit on an issue of substantive federal law as to an Indian reservation that spans 3 states. So basically the plant would be treated differently in Arizona than it would be in Nevada or in California, and certainly Nevada would not tax it because Nevada applies record to this ruling. And there's we just found right before the argument an older Attorney General opinion that says, oh, you can't tax that, it's a permanent improvement, see record. The federal courts have been entirely consistent that this is all about ad valorem property taxes on permanent improvements to leased tribal land. And once it's a permanent improvement to leased tribal land, it's off the table as far as state taxing authorities. And, you know, the courts have said the state can't get around that by redefining the way it taxes it. And the record says that, Mescalero says that, Ninth Circuit and Chehalis says it. These are matters of federal law, and the federal test applies. And that's what Washington, which was fighting Chehalis reservation, concluded when all was said and done, that it didn't depend on who owned it. There was no majority or, you know, even de minimis Indian ownership requirement, and it applied under federal law to all permanent improvements. The second ground of preemption, which is really independent of the first, is the Bracker balancing test. And this is supposed to be a balancing test. If it can never come out in favor of preemption, then it's really no balancing test at all. And the test is the interest in the facility, not the tribal members, not anyone else. It's what is the state or local government's interest in the facility. If there were ever a case in which Bracker balancing favored preemption, it's this. That's because, first, the nature of the tax. None of the other Bracker cases are ad valorem property taxes on reservation, on property on reservation. And the amici, you know, the Navajo Nation and the Fort Mojave Indian Tribe and the National Congress of the American Indian and the others have all been clear that because this is a tax on property on a reservation, even though it's owned by non-Indian lessees, it strikes to the heart of the ability of Indian tribes to use their land, whether themselves or by leasing it to non-Indian owners. It's also because of the nature of the tax facility. This is an on-reservation plan that doesn't serve off-reservation county or state residents. It's not a smoke shop. It's not Compton Terrace. It's not the pavilions, kind of Scottsdale adjacent. It's a facility that brings in its supplies it needs over federal land and ships out its power over there. It really has nothing to do with supplying people. It's not a tax dodge. It's there because this was a location that was appropriate for siting this kind of facility because of the guaranteed water supply from the Colorado River allocation for the tribe and the proximity of the transmission lines over BLM land to take it to the grid. And there's also the absence of any state or local interest in this facility. All the Department of Revenue in Mojave County can produce is the result of the fact that the reservation is within the borders of the state and county, and that the tribal residents and the employees at the facility are American citizens who enjoy all the privileges and immunities of American citizens. Yeah, they can go to local schools. Their children can go to local schools. They can go to community colleges. But has nothing to do with the facility. That has to do with the fact that they're American citizens who live here, who live in the county. The only interest that they can come up with is basically that this tax allows them to raise general fund money to fund government programs that they would have to fund anyway. That is simply not enough under the prevailing law. It's certainly not enough for a property tax that strikes to the heart of the Indian tribe's ability to harness the value in their land for their tribe's for their tribe's benefit. And the defendants say, well, the economic incidence of the tax is on SPEC, not on Calpine, not on the tribe. But that's not what the tribe says, and it's not what the facts indicate. This is an all money is fungible situation. If the state and local governments get to tax the tribe, that means there is less money available for the tribe. Whether they do it, the tribe gives up the money by foregoing taxes or by rebating taxes or by just getting less money in rent or lease payments. And that's why the BIA says, look, when it comes to any kind of balancing, the thumb is on the scale of preemption because these kinds of taxes on permanent improvements to reservations impede the ability of tribes to use their land. It essentially always ends up coming out of the tribe, and the history of negotiations bear that out in this particular case. I see that I have about 4 minutes left. Unless the court has questions, I'd like to reserve that for rebuttal.
Thank you.
All right, thank you, counsel.
Good morning. My name is Kimberly Seigan, and I represent the Arizona Department of Revenue and Mojave County. I think it may be helpful to explain at the outset how we got here and clear up some of the confusion as to what the tax court decided and what the tax court didn't decide. The first issue that the parties briefed and litigated was the categorical preemption for permanent improvements. And in the first minute entry that the court did, the court found that the tribe can and did alienate its rights and improvements. So it cited the Cass County case, which although is factually different, it stands for the concept that ownership rights can be alienated. So if a tribe can alienate its rights in land, then it certainly can alienate its rights and improvements, and it certainly can alienate its rights and improvements that it never had a right to in the first place. The parties to the lease made it clear that these improvements belong to South Point, not the tribe. These improvements were not taken into trust like the land was under the statute. So the court found that the tribe had no interest in the improvements. What the court was uncertain about was whether the tribe was somehow using South Point to do business. And so that's why it didn't grant summary judgment either way. So the court said in the first minute entry, although it is difficult to see how an entity entirely owned by non-Indians might serve as a forum in which the tribe would conduct its business, that is a possible conclusion. So Judge Whitten wanted to develop a record under Bracker to make sure that the tribe had no interest in South Point's business. And then, of course, then the second phase of the litigation was Bracker. And by the end of the Bracker phase, it was finally clear to the court that the tribe had no interest in South Point's business. So in the second minute entry, the court stated on page 3, here there are no permanent improvements or fixed property treated as tribal land. The court found there was no categorical preemption because there was no Indian interest in the improvements. The improvements, he found, did not run with the tribal land. The court, however, never determined the permanent improvements versus personal property issue. He didn't even have to go there because he had already found that there was no categorical preemption.
You know, counsel, I struggle with that argument for the simple fact that the tribe was getting millions of dollars. How can they not have an interest in the business? It's to their advantage to have that business up and functioning and receiving rents from the land.
Right, but they weren't heavily involved in the operations of the plant. That's what the court was concerned about. As you recall in the Chehalis case, there the tribe owned 51% of the business. And in that case also, the tribe and the non-Indian, they were very, very careful about how they structured the entity as a joint venture to make sure that they could take advantage of the tribe's immunity. Here, the tribe doesn't do anything other than just collect its rent money. That's it. It doesn't have any involvement in the operations of the power plant itself.
But it's to their great advantage if they can rent out some of their land, knowing full well that they're going to be competitive, even more competitive than neighboring lands, because they won't have to pay tax on the Indian land.
But isn't that more of a question of a Bracker, whether it affects their ability to rent out the land?
No,
or not?
It seems to me that it has a direct bearing on the interest of the business itself.
But again, there is no evidence in this case that the tribe was unable to rent out its land. There's simply nothing that the tax is doing here that interfered with any tribal business. I guess, why would you give a non-Indian immunity when the whole purpose of categorical preemption is to protect tribes and their property? It's not to protect non-Indians. And that's what's going to happen here. If you order a refund, it ain't going to the tribe. It's going to South Point. So they're going to get a huge windfall of $35 million in taxes, and in addition, a free ride going forward. Because we're like, 20 years into the lease? So for another 30 years, they're going to get a free ride on this. And South Point hasn't shown any harm whatsoever that this tax has had on the tribe.
Can you properly analyze CAS if you're making an assumption about permanent property by not first going through the Whiteco analysis? I mean, in reading his minute entry, he says, it's not exempt, it's not real property on its face, statute exempts land and rights in land, and this is just clearly permanent or personal, so let's move on. And then I can do the CAS. But if he hasn't done Whiteco, how can he have properly analyzed it under CAS?
Because it doesn't matter for categorical preemption. Once he decided that there was no categorical preemption, it didn't matter whether there were permanent improvements or personal property. He didn't decide that issue. He didn't have to. His statement there is he's simply finding that these permanent improvements are not connected to the tribal land because the tribe has no interest in the improvements. That's all he's saying. He's not saying that the facility is a permanent improvement. He's just saying it's not. Let's look at what he says. For example, in the second minute entry, on page 2, he says, the pervasiveness of federal regulation of tribal leases is thus immaterial. I'm sorry, I'm reading the wrong thing. At the top. If South Point retains the right to remove an improvement, that improvement is by definition not a permanent improvement, which becomes part of the realty. So he's just saying there that the permanent improvement is not running with the tribal land. He's finding that there's no Indian interest whatsoever in the permanent improvement. He's not saying that the facility is a permanent improvement. He's just simply saying that they don't have any interest in permanent improvements. So he's saying that there is no categorical preemption. That's all he's saying. He's not making a ruling that the facility is a permanent improvement or whether it's personal property or any concept. He's simply saying there is no categorical preemption. And his first minute entry, you can see he's concerned that this might just be a case where the tribe is selling its exemption. But he wants to make very clear that this is not a situation where the tribe is somehow doing business with South Point, like the tribe was doing business with the non-Indian in Chehalis. That's why he wanted a Bracker analysis. And that's all the court found. He's found no categorical preemption. And then, of course, he did the Bracker analysis, and he found that there were no tribal interests or federal interests that the tax was interfering with. And so he found that the tax was not preempted on under a Bracker analysis. So the only issues that you have to decide are permanent improvements that a tribe has absolutely no interest in, are they categorically preempted? And then does Bracker preempt the tax here when there's no evidence of any real harm? So I'd like to start with the categorical preemption. No court in the entire United States has ever held that categorical preemption applies to improvements that are exclusively 100% owned by a non-Indian. Now, South Point is throwing a lot of stuff at you to make you think that the tax is on the tribe.
Well, what's the inverse? What case do you have that is like this case? Because the way I read record was that once you assess that there's been permanent improvements on land that cannot be taxed, that you can't tax it.
Pickerel, we cited that as our supplemental citation of authority. That's a case where non-Indians owned cabin around a lake. It was on trust land, and there the court said that the county in that case could tax the permanent improvements.
All right.
Just because this is a property tax does not make the tribe any more liable for it. This is a tax only on South Point's property. Now, South Point argues that the tax is actually on the property, not the owner. The point is that the tax is still not on the tribe. So technically, the property at issue and the property owner are the same. It's the property owner who pays the tax, and it's the property owner that has the appeal rights. But whether the tax falls on the property or the property owner, it's not on the tribe. It's not the tribe's liability. The other thing that South Point brings up is the lien. Again, the lien can only extend to South Point's property. It's never going to implicate the tribe's land. Federal law prohibits that, and also under Arizona law, the only property to which a lien can attach is property that's accessible. And under the Arizona Constitution, tribal land is not accessible. So a lien is never, ever going to attach to the tribe's property here.
So how would you ever be able to, if they refuse to pay, then what's your remedy?
Well, that would be a bridge that the county would have to get to. It gets to that point. But the other thing that South
What
Point...
legal remedy do you have other than attaching?
Well, again, the county could sell the property, but South Point argues that somehow the a lessee could come in that the tribe didn't want that would occupy the plant, but that would never happen because the county cannot sell the lease. And it can't sell the leasehold interest. This is not a tax on the leasehold interest. So this idea that some stranger is going to come in and occupy and start operating the plant is just a fiction. It's just never, ever going to happen. And the thing, too, is that it's highly unlikely that a lien is ever even going to occur as to South Point's property. This is a really valuable plant. It's valued at over $150 million. So it's unlikely that South Point is ever going to let it get to the point where a lien is going to attach. It's not going to walk away from this plant. Even when the plant was mothballed in 2016, South Point was still paying property taxes on that plant. So it's just highly unlikely that a lien is ever going to occur as to South Point's property.
Okay, but you don't have any other remedy at law that you could use to get back the money that you would say is owing as a property tax, correct?
That's correct. But again, as we pointed out in our response to the tribe's amicus brief, that's a different issue. It's separate from the propriety of the tax, whether the tax is valid or not, and the remedy. Those are two different issues. And again, my main point, though, is that it does not implicate the tribe in any way. Nobody is going to come in and start occupying and operating this power plant if it did get to that point. It's just a fiction. South Point also makes a big deal about the Ninth Circuit statement in the Chehalis case that improvements are categorically preempted without regard to ownership. But I think you have to look at that statement in the proper context, and when you read it in that context, the court is most likely referring to the form in which the tribe owns the property, not to give non-immunity, or not to give non-Indians automatic tax immunity. And there's several reasons why. First of all the cases that were cited by the court in Chehalis all involved Indian-owned improvements. And the purpose behind categorical preemption is to protect Indians and their property. It's not to protect non-Indians. And in fact, the Supreme Court has stated that there is no categorical preemption for non-Indians. And the Supreme
But
Court
they
is
weren't
also...
talking about ad valorem taxes.
That is correct. That is
In
correct.
any
But in
of the
general...
cases that have come after, correct?
That is correct, but there's nothing special about property taxes, like I mentioned.
Sorry about that.
There's nothing special about property taxes here. It's still the tax is not on the tribe. It doesn't implicate the tribe. And again, what I was saying before is that the Supreme Court has expressed concern about the tribes selling their tax exemption. And in Chehalis, there were compelling facts. As I mentioned before, the tribe was heavily involved in that activity. It owned 51% of the improvements. They structured the entity that they did business in very carefully in order to make sure that they were able to take advantage of the tribe's sovereign immunity. And finally, my last point is why? Why would, if the purpose is to protect non-Indians, or to protect Indians, why would you give automatic tax immunity to a non-Indian without looking at any facts at all? Especially here, where, as I mentioned before, too, this represents a huge windfall.
But isn't that a policy issue that has nothing to do with this court? I mean, seriously, it doesn't, does it? You're asking us to, why would we do that? Well, that's not, the question is not why would we do that. The question is, has it been done? Or is that the law? Because we don't determine that kind of policy. But the real question I have for you is, what is your position as it relates to the improvements? Are they permanent or not?
The facility is comprised of both permanent improvements and personal property.
And when we say personal property, is it de minimis? Like counsel said, it's just desks, chairs.
I disagree with that. We would have to do if you rule that categorical preemption applied, then we'd have to go back to the tax court and remand that issue and do discovery and whatnot and determine what part of the plant. Generators can be sold, so that could constitute personal property. So again, it would be an issue that we would have to remand back to the tax court. And I don't agree that it's de minimis at all. We would have to develop a record and, like I said, do discovery and probably have experts testify as to what constitutes permanent improvements and what constitutes personal property.
Were you doing tiered discovery in your three kind of initially how the case was set out, that you were going to go through 3 rounds of motions for summary judgment? Were you tiering discovery to go along with each?
That is correct, yes.
Yeah.
Yes, we'd already done discovery.
So you believe there's discovery that is yet to be unearthed regarding the permanent versus personal property aspect of the case?
Yes, I do.
Okay.
So I would like to go ahead
Just so
and...
we're clear,
Okay.
you agree that there is some permanency to some of the property that exists in this facility?
The facility is comprised of both personal property and permanent improvements, yes.
Okay.
And that's why we had structured the scheduling order that way, that we would first argue categorical preemption, and then we would argue and litigate the permanent improvement versus personal property aspect of it, and then finally Bracker. But like I said, the court ruled that there was no categorical preemption, so we never had to get to that second phase. We went right away to the third phase, to Bracker.
But you disagree, I mean, Judge Whitten believed this was personal property. You disagree with that?
I don't think that's what he was saying. Granted, he didn't say it as artfully as he could have, but I think what the concept that he was trying to communicate was that there was no there was no permanent improvements that ran with the tribal land, that the lease had severed ownership of the improvements to the land, and that the tribe had alienated any right in the permanent improvements. I think that is what he's trying to say. It's not connected to the tribal land.
And
When he
that's,
talks about
and that's
permanent-
based upon the lease requiring them to take it to tear it down at the end of?
No, the ownership of the improvements is totally with South Point. There's no tribal ownership.
Well, if it's permanent and the lease runs out, typically it stays. So
Right, well, no, but in this case, it's my understanding then the South Point must remove it. They must meet, but I don't think they meet at the end. It's because the tribe has any interest in the improvements. I suspect this is a power plant. They probably are meeting in order to address any kind of environmental concerns and that nature. But it's not because that the tribe has any interest in the improvements. Keep in mind, too, this is, at the end of the lease, this is going to be a 50-year-old power plant. I suspect it's going to be obsolete by that time. Who's going to want a 50-year-old power plant?
Oh, I didn't know that. And let's assume for the sake of argument, or just the sake of this discussion, that at the end of the lease period, the power plant is still profitable.
Right, but again, for valuation.
It seems at that point in time, the tribe can either negotiate an extension on the lease, and if they can't negotiate that extension, they can actually take it over.
Right, but we're valuing the property as of today, or as of the valuation date. So what happens 50 years from now?
Right.
It doesn't matter. What we're concerned with about today is what is going on with the plant now. And it's clear that the tribe has no ownership in either the permanent improvements or in South Point's business itself. So I'd like to go ahead and move on to the Bracker phase, unless you have any more questions about categorical preemption. The Bracker analysis, it's not a question of who provides the most services or who has the most regulations. The question is, what is the tax doing? And it's also not a question of what the tax might do or what it has the potential to do. Bracker has been described as a fact-intensive inquiry, which implies that you must have actual facts, not speculation, not hypotheticals. And South Point has provided nothing to show that the tax interferes with any federal or tribal interest here. And now South Point makes the argument that the tribe gave up its right to impose future taxes. Well, no, the property tax here did not do that. The tribe agreed to forego imposing future taxes in exchange for $27 million up front and $18 million in annual payments. But the tribe simply accelerated the payments that it was owed under the lease. There's no evidence that the tribe could have gotten any more under the lease, any more money under the lease, but for the tax. South Point also made the argument about the offset that the tribe changed its tax code by providing an offset for the tribal tax. But again, there's no evidence this offset ever occurred as to South Point or as to any other taxpayer. And courts have routinely rejected double taxation as a grounds for preemption. We cited numerous cases in the brief, like Gila River and Cotton Petroleum, that says that the double taxation is not enough.
Thank you, counsel. Your time has expired. Mr. Cooper, any final word?
Yes, Your Honor. With all respect to Ms. Seigan, who I've litigated a number of tax cases with, there's an air of unreality to some of the arguments here. She said, I believe her language was, there's nothing special about property taxes. In fact, there is everything special about property taxes. Arizona has chosen in this instance to rely on a singularly preempted tax. It could have gone back to the possessory interest tax that abolished 25 years ago that California uses. It didn't. That's at least an excise tax on ownership. This is not. I'm surprised to see the revival of Cass County case here, because the tax court pulled that out of its own research. No one had ever cited it. And we explained why it had no bearing on this case, and the department and the county in their answering brief didn't cite Cass County either. That was a case where the reservation land had been sold off to non-Indians and then in fee simple, and then the tribe later bought it back, but it wasn't in trust. And so the Supreme Court said, well, it's taxable. It's not trust land one way or another. That's got nothing to do with this idea that you can somehow alienate permanent improvements from the land. No one thinks that's the case when it comes to permanent improvements to the land.
What about this case she just mentioned to me when I was asking her that question?
Oh, yes, Pickerel Lake. That is a very interesting case because what it doesn't address. What the court said in Pickerel Lake was, which just came out, And it said that Section 465, which is Section 5 of the Indian Reorganization Act, doesn't apply because this land was put into trust before the 1934 Act was passed. It doesn't cite the Supreme Court's Mescalero case, footnote 11, which said we're not going to get into the niceties of that. What was the United States supposed to do? Transfer it to itself? Doesn't cite that. It doesn't deal with what the law was for permanent improvements to leased tribal lands before the 1934 Act, like the Rickard case. It doesn't cite Chehalis. It doesn't cite the Ninth Circuit's decision in Santa Rosa, which, as our supplemental authority indicates, is still good law and says that there's no dividing line from 1934. 1934 codified what the protections always were, so none of this works. So you've got the South Dakota decision that comes out of the blue, cites none of the relevant case law, and just says, well, we don't think Section 5 of the Indian Reorganization Act applies. There is no factual development in this case. Fort Mojave this is land that was held in trust for a tribe that is organized under the Indian Reorganization Act. That is undisputed in the record. So in light of the footnote 11 in Mescalero, unless there's something weird about the land at issue in Pickerel Lake, it's simply wrong as to the law, and it doesn't cite or deal with any of the relevant law. And it was surprising to see it. I read it. I looked at the footnotes, tried to figure out how it addressed any of the relevant law. It's not clear that anything was cited to the court, with all respect. So it's not surprising that it got wrong. But it's relying on a temporal distinction that the state and the county have never raised in this case. In this case, I think it's interesting, Ms. Heigen said, well, that's a bridge we don't have to cross. That is, what remedy you have. Well, the reason there's no obvious remedy if we were ever to stop paying taxes is because this is a tax on property, not a tax on owners. She would not have to tell you, wait for the later bridge, if this had actually, the incidence of the tax had actually been on non-Indians. It's on the property, and they can't tax that property, regardless of who owns it, because in the end, it's a permanent improvement to Indian trust lands. And the lesson since Rickard has been, you can't tax permanent improvements to Indian trust land. But this court doesn't have to get to that issue if it finds Bracker preemption as well, because then it's all covered.
Thank you, Mr. Cooper. The matter is deemed submitted. We'll issue a decision in due course.